Assalamualaikum warahmatullahi wabarakatuh. We are from Group 1, present about Case Study 1, supervised by PM Dato Dr. Sabri bin Muhammad Sharif.
This is my team members. First, myself, Edina Ilazri bin Tawak Mazri. My matrix number B0623108110.
My name is Nurul Ilyani binti Abdul Hamid. My matric number B0623100520.
Hello, my name is Kishan Kumar and my matric card number is B0623106884.
Hi, Assalamualaikum. My name is Nuri Nabiha binti Kamari. My matric number is B0623100136.
Hi everyone, my name is Nur Sazwani binti Rilmati and my matrix number is B0623100649.
Hi, Assalamualaikum. My name is Amira Munira binti Masham and my matrix number is B0623100676.
Hi everyone, my name is Teo Pogi. My matric number is B0623100040.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Maizatul Akmal binti Rozi. Matrix number B0623101168.
Assalamualaikum and hi everyone. Today I will briefly present the background and purpose of our topic, which is contract formation in business law. Contract formation is essential because it explains how legal agreements are created between individuals or companies. In business, contract help ensure both parties fulfill their promises. In Malaysia, this process is mainly guided by Contract Act 1950, which is outlined the legal requirement for a valid agreement. The main purpose of studying contract formation is to help us understand the difference between casual promises and legally binding contracts. This knowledge is especially important in business to avoid misunderstandings or disputes. By understanding key elements like offer, acceptance, consideration, and legal attention, we can make smarter decisions and protect our rights. Lastly, this report is structured to explain the difference between agreements and contract, the key legal element involved, and real-life example to support our discussion. Thank you.
So what is contract? A contract is, according to Section 2H of the same Act, an agreement enforceable by law. So it means here that for an agreement to constitute a contract, it must fulfill legal conditions specified under the Act Section 10(1) of the Contract Act 1950 that states all agreements are contract if they are made by the free consent of parties who are competent to contract for a lawful consideration and with a lawful object and are not here expressly declared to be void. Therefore, a contract must be backed by free consent, capacity, consideration, and also lawful object in order to be legally enforceable here in Malaysia. However, a contract and agreement are synonymous but related legal terms. According to the Contracts Act 1950, an agreement in Section 2E is every promise and every set of promises forming the consideration on for each other. So it means that when two or more parties are agree on something and make promises to one another for something valuable, an agreement is already formed. Not all agreements, however, are legally enforceable.
Assalamualaikum and good day everyone. Today I will explain three important elements that make a contract valid under Malaysian law: offer, consideration, and acceptance. First is the offer. An offer is when someone makes a clear proposal and expect the other person to accept it. This is defined in Section 2A of the Contracts Act 1950. This is defined. A famous case is Carlill with Carbolic Smoke Ball Co. 1893, where the company promised a reward for using their product since they clearly stated it and even deposited money. The court said it was a real offer. In Pharmaceutical Society v. Boots 1953, the court explained that putting item on display is not an offer, it's just an invitation to buy. Okay, next is consideration. This means something of value given in return for a promise. It can be money, goods, or even a small amount, as long as it has value in the eyes of the law. This is explained in Section 2D of the Contract Act 1950 in Thomas v. Thomas, 1842. A woman paid one per year and that was accepted as valid consideration, even though it was a small amount. Another example is Curry v. Misau, 1875. The court said consideration can be a benefit to one side or a loss to the other. Okay, the third element is acceptance. This is covered under Section 2B of the Contract Act 1950. The acceptance must be clear and follow the exact terms of the offer. In Hyde v. Range, 1840, the court said if you make a counter offer, the original offer is cancelled. And thus, we must 1950 shows that if acceptance is sent through instant communication, it only counts when it's received. And Feldhaus v. Bentley, 1892, the court said silence does not mean acceptance. You must clearly say yes. So in short, a valid contract needs and offers something of value as consideration and clear acceptance. All three must be present for the contract to be enforceable. That's all for me. Thank you.
Today, I will be explaining three important elements of a valid contract under the Contract Action 1950 are intention to create legal relation, certainty, and legal capacity. Let's start with the first one, which is intention to create legal relation. This simply means that both parties must want the agreement to be legally binding. In Balfour versus Balfour, a husband promised to pay his wife, but the court said it wasn't legally binding. Why? Because it was a domestic agreement between a husband and wife living together. However, in married versus married, the couple had separated. They wrote down their agreement, so the court said it was legally binding. This shows that in family or social situation, the law assumes there is no intention unless it is clearly shown. In business settings, it is the opposite. The law assumes both sides do intend to be bound, but this can be changed. For example, in Rose and Frank Co. versus J.R. Compton, there was a clause saying the agreement wasn't legally binding and the court respected that. So, intention depends on the context and it must be clear. Next, let's talk about certainty. Even if there is an offer and acceptance, the contract must have a clear terms. Under Section 30 of the Contract Action 1950, if the terms are vague, the agreement is void. For example, in Gedung versus Lane, the buyer promised to pay extra if the horse was lucky, but the court said lucky was too vague, so the agreement did not count. So, important terms like price, quantity, or delivery must be definite. If the terms are unclear, the contract cannot be enforced. Finally, legal capacity. Under Section 11 of the Contract Action 1950, a person must be 18 years old or older, be of sound mind, and not be disqualified by law. For example, in Nash versus Inman, a minor bought items that were not essential. The court said the contract was void. In Imperial Loan Co. Ltd versus Stone, the contract was made with someone who had mental incapacity. The court ruled it was not valid. This shows that if someone is too young or mentally unfit, they cannot enter into a valid contract. To wrap it up, a valid contract under the Contract Action 1950 needs intention, certainty, and also legal capacity. Without this, an agreement may not be enforceable.
Today, I will briefly explain three essential legal elements that make a contract valid under the Malaysian Contract Act 1950, which is free consent, legality of object, and required formalities. So first, we have free consent. According to Section 10, Subsection 1 and Section 14 of the Act, consent must be given freely without being affected by coercion, undue influence, fraud, misrepresentation, or mistake. A good example is the case of Terry v. Pick, 1889. In the case, the court wrote that misrepresentation made the contract voidable, meaning that affected party could choose to cancel it. Okay, next we have the legality of object as explained in section 24. So a contract must have a legal and moral purpose. It becomes invalid if the object is forbidden by law like drug trafficking, defeats legal provisions, or is immoral or against public policy. Okay, for example, in Person v. Brooks, 1866, a contract involving immoral activity was ruled unenforceable even though both parties agreed to it. Okay, lastly, we must consider required formalities. While many contracts can be made orally, some must meet specific requirements like being written, signed, registered, or stamped. This ensures legal clarity and help prevent fraud. Okay, an example is Tan Swie Ho Company Limited versus Ali Hussein Bros 1918. Okay, a land sale agreement was ruled unenforceable because it lacked proper documentation, even though other elements like consent and agreement were present. Okay, so in conclusion, even if there is agreement and consideration, a contract may still be invalid if any of these three elements are missing. Okay, all three, which is free consent, legal object, and required formalities, must be fulfilled to ensure the contract is valid, legal, and enforceable. That's all from me. Thank you.
Today, I will be discussing the fundamental principle of contract law. Every contract must be built on a valid agreement, focusing on three key areas. The first one is offer and acceptance. The second one is intention to create legal relations. The last one is certainty. Every valid contract begins with a clear agreement, formed through the process of offer and acceptance, often referred to as a meeting of the mind. A famous case that is related is Carlill with Carbolic Smoke Ball Co. 1893. In this case, a company made a public offer and customer accepted it by using the product as instructor. The court held that her action amounted to acceptance, proving that conduct can form part of the mining agreement. However, not all agreements are enforceable. For a contract to be valid, the parties must intend to create legal obligations. This is usually presumed in commercial agreement, but not in domestic or social agreement. For instance, in Balfour v. Balfour 1919, an agreement between a husband and wife was not seen as legally binding. Similarly, in Jones v. Butterworth 1969, A promise from a mother to her daughter was also found to be non-binding domestic agreement. Lastly, the terms of a contract must be certain. If any agreement is too vague, the courts cannot enforce it. This was the case in Scammer v. Austin 1941, where the terms on hire purchase terms was considered too ambiguous, and therefore no contract was found to exist. In summary, a contract is only valid if there's clear agreement. Both sides intended it to be legally binding, and the terms are certain. Without this, an agreement can't be enforced by law.
Good afternoon, and now I want to present about not all agreements are contract, and there are 5 main points. And then the first one I want to present is not all agreements are contract. Only those meetings legal requirements like offer, acceptance, intentions, and certainty are enforceable. And then the second one, a meeting of the mind is vital, as seen in Carlill with Carbolic Smoke Ball Co in 1893, where acceptance by conduct form a binding contract. And the third one is intention to create legal relation is essential. In Balfour 1919, a domestic promise law enforceable. And then the fourth one is contract must be clear and certain. Camel v. Houston 1941 shows that the value terms render agreements are unenforceable. And the last one is in Jones v. Paraweton 1969. The court ruled that a family promise lacked legal intent, which is reinforcing that not all accepted offers are contract.
Good day everyone, I will begin with the legal framework for contract formation in Malaysia, which is governed by the Contract Act 1950. Section 2, subsection H, defines a contract as an agreement enforceable by law. Then Section 10, subsection 1, lists the key elements required to make a contract valid. These include free consent, legal considerations, lawful object, and competent parties. Section 2, subsection A, defines an offer, which is proposal made to another party. Section 2, subsection B, defines acceptance, which must be absolute, meaning no changes to the original offer. Section 11 talks about who is competent to contract, only those who are of age, of sound mind, and not disqualified. Lastly, Section 14 explains that consent must be free, not given under pressure, fraud, or mistake. Now, let's look at some important cases. In Carlill versus Carbolic Smoke Ball, a woman accepted an offer by using the product, and the court ruled that there was a valid contract, even though the acceptance was through her action. In Balfour versus Balfour, a husband promised his wife a monthly payment, but the court said it was a domestic agreement without legal intention, so no contract. The Boots case clarified that displaying item in store is not an offer, but just an invitation to trade. Mori Bibi versus Damoda's Coast showed that contract with minors are not valid. And in Chapel versus Nestle, the court confirmed that any valuable considerations, even something small, is enough for a valid contract. To conclude, the phrase all contracts are agreements, but not all agreements are contract, remind us that not every agreement can be enforced by law. For an agreement to become a valid contract, it must meet all legal requirements like offer, acceptance, intentions, considerations, and capacity. If any of these are missing, the contract may be void or unenforceable. These legal rules and case laws help protect both parties and ensure fairness in business and legal transactions.
Let's challenge our understanding. The first question is, what are the essential elements required to form a valid contract under Malaysian law, and why are they important?
For this question, I will answer first. The core elements of a valid contract include offer, acceptance, considerations, and intention to create legal relations. These form the foundation of a contract. An offer shows willingness to enter into an agreement. Acceptance confirms it, and consideration provide the value exchange. The intention to be legally bound ensures that the parties are serious about fulfilling the agreement. Without these, the agreements remain informal and cannot be enforced by law, which may lead to dispute or unfair situations. I think that's all for me. I will pass to the next person.
Two important elements are legal capacity and free consent. Legal capacity ensures that the people involved are legally qualified to enter into a contract, such as being of sound mind and not a minor. Free consent means that both parties agree to terms willingly without pressure, deception, or misunderstanding. For example, signing under or misrepresentation can be declared void or voidable. These two elements protect individuals from exploitation and uphold fairness in agreement.
The element of certainty is very vital because the law requires that the contract terms may be clear and also specific. If the agreement is to work like I saying, I will pay you more if the product is good. So courts cannot enforce it, as shown in Cutting versus Lin law. So certainty, these help both parties to understand exactly what they are agreeing to. So it prevents confusions and also ensure that all the obligations are clearly defined, this is very essential for effective business and also legal relationship.
Two more important elements are legality of object and required formalities. The contract purpose must be legal and not go against public policy. For example, a contract involving illegal activity like drug trafficking is automatically void. Also, some contract must be in writing or signed, such as land sales to be valid, as seen in Tan Sui Hui versus Ali Hussein Bros. A lack of proper documentation can make the agreement unenforceable. These rules ensure that contracts are transparent, ethical, and properly decoded.
Question 2. Why is the statement all contracts are agreements but not all agreements are contract significant in contract law?
My answer is this statement is significant because it draws attention to facts that not every agreement is legally enforceable. Under the Contract Act 1950, only agreement that meet specific legal criteria such as offer acceptance, lawful consideration, and legal capacity can become valid contracts. For example, if a minor agrees to something, the agreement may not be enforceable because the party lacks legal capacity. This distinction help protect the vulnerable parties and ensure fairness in legal linings.
The statement underlines the importance of intention to create legal relations. In some relationships, especially family or social settings, the law assumes there is no intention to be legally bound. A good example is Jones v. Peddleton, where a mother's promise to support her daughter was seen as domestic arrangement, not a contract. This shows that even if there is mutual action, the court won't enforce it without clear legal intention.
This principle is essential because it helps distinguish between serious legal agreements and informal promises. For instance, friends or family members may agree on good things in good faith, but unless there is clear intention and lawful consideration and certainty of terms, the agreement is not enforceable. This protects people from being dragged into legal disputes over casual or non-serious promises.
The answer is the statement plays a key role in filtering out agreements that should not be enforced by law. Just because someone makes a promise doesn't mean the law will enforce it. For example, if someone casually promised to give a gift and later change their mind, it's not considered a breach of contract unless all legal elements are present. They help prevent misuse of legal system and ensures that only properly formed contracts are enforced.
That's all from us. Thank you. Bye bye.